Good morning and welcome to the 24th meeting of the committee in 2019. I'd like to remind members of the public to turn off their mobile phones and members of the committee using electronic devices to access committee papers should ensure they're turned to silent. We've received apologies from Annabel Ewing, MSP, and I welcome Emma Harper, MSP, who is attending as a substitute member. Welcome, Emma. Our first item on the agenda today is the committee's continued consideration of the UEFA European Championship Scotland Bill at Stage 1. And I'd like to welcome to the meeting Gillian McNaught, Senior Solicitor, Licensing and Democratic Services, and Neil Coltart, Group Manager for Trading Standards, both from Glasgow City Council. And also Andrew Niven, who's the Project Leader for the Scottish Football Association, Peter Dallas, who's the Managing Director of Hampden Park Limited, and Michael Short, who is Legal Counsel for UEFA. Welcome and thank you for coming to give evidence to us this morning. I would like to ask UEFA a couple of questions first. I know that you were here last week to listen to the first evidence session that we had with the Scottish Police Federation and others. You'll be aware that there was some discussion about the timetable for this legislation. Can I ask you, when did you first make it clear to the Scottish Government that primary legislation was needed?
Of course. Firstly, very much thank you for welcoming me to this committee this morning. I appreciate the chance to speak to you. On that particular question, the bidding process which took place a significant period of time ago made it mention of primary legislation being a possibility across the board for all host cities in the original bid dossier documentation. In terms of Scotland or Glasgow, specifically, in the feedback to that bid, when Glasgow was successful, there was a reference to the need for improved legislation, but the options were left available to the whole city, as they almost always are. The most specific reference to primary legislation being made clear was in the early stages of 2019, where we had meetings in Glasgow. That was followed up by an official letter in April of 2019.
So, but the actual cities were agreed in 2014, I understand it.
Indeed, yeah, and that is the earliest stage at which legislation, or at least legislative tools of some sort, are mentioned to all host cities as a matter of need to meet the certain standards outlined as the Rights Protection Programme.
Right, okay. So my understanding is that not all host cities or countries are bringing forward primary legislation. I think it's 4 out of the 12, if I remember correctly. So why do some cities need primary legislation and others seem to be able to do this by regulations? I understand in England, for example, it's done by regulations at council level.
Absolutely, that is indeed the case. The position from UEFA's point of view is that primary legislation is mentioned throughout the early stages of the bidding process as a possibility. It is often the easiest way for a host country to standardise the level of protection and to offer consistency and clarity to local businesses and to the host associations itself and the event organisers such as us. So that's why it's mentioned early on. However, it's not mandated. The thing that is mandated is the level of protection, the requirement level, which is set out by UEFA and discussed with the host cities, is equal and standard across the board. The tools to get to that level, to get to that requirement, are up to the host cities. The journey to get there is one that we work with them on, and they choose the route to get there, provided that they can get there. For some host countries, primary legislation has been the obvious or lowest friction route to get there. In other countries, secondary legislation, municipality decrees, local authority changes to bylaws are being utilised. And in some other cases, it is simply a case of using existing laws but reallocating resources in a different way and or utilising powers that are temporary. So the unique nature of this particular Euro across 12 jurisdictions, 12 countries, 12 different sets of laws meeting one requirement level is very difficult. So therefore, everybody has to use their own different tools to get there. And we welcome wholeheartedly the Scottish Government's choice of route here, given the benefits that primary legislation brings with it.
Right, okay. Because I guess the impression we're left with last week, and certainly in terms of some of our briefing papers, was that there had been an attempt to do this using regulations, and there had been an ongoing dialogue between the Scottish Government and yourself over time, which resulted in you insisting on primary legislation at the end of the day. Are you telling me that that's not the case?
The way I'd phrase it is that, yes, there was absolutely an ongoing discussion about whether existing laws, existing regulations, and existing tools met the requirements. That took a long period of time to complete that discussion. UEFA is having to have that discussion across 12 countries, so it's a very complex task for us to undertake. But that did take a bit of time. When we got to the end of that discussion, it was clear from all stakeholders that primary legislation was the preferred route. It was mentioned, we have physical meetings where we came over to discuss this particular issue in Hampden, I think, right? In early 2019 or late 2018. And every party across around the table realised, and I believe anyway, agreed that primary legislation seemed like the most efficient, pragmatic and proportionate route to take here. Okay. So yes, it was an ongoing discussion, and it's never mandated by us. We did send a letter in April suggesting that this was the preferred course of action for all stakeholders. So right. We did say that eventually.
Okay. If I could maybe ask our witnesses from Glasgow City Council, why did it take so long to realise that you needed primary legislation, given that you'd already had the Commonwealth Games and you presumably understood the shortcomings in Scottish legislation around these matters already?
I should make it clear that from my perspective in relation to the trading and advertising provisions, we had discussions at Hampden and elsewhere about the fact that the current legislation that involves trade or restricting trade or potentially restricting trade wouldn't have been effective in terms of the the bid document requirements. So we had those discussions and they were going on over a period of time. It was hoped that some movement could be made in relation to how to resolve that, but eventually what we agreed, or not agreed, what we recommended in January of this year was that primary legislation was the only route to fix this.
You hope that some movement could be made by UEFA?
Movement in general, both in terms of what the plan would look like, how we would carry that out, and also an understanding of the requirements in relation to permissions to trade and permissions to advertise. And it was clear that in relation to the kind of core protections for ticket touting, advertising and street trading, that the current legislation we have wouldn't have satisfied the requirements for the UEFA bid.
Yeah, but you should have known that quite a long time ago. That's my point. You presumably knew that at an earlier stage. I mean, this committee has a particular interest here because we've been we're dealing with this legislation at really quite short notice, and it's affected our work programme in other areas. So we have a particular interest in knowing why it was so last minute.
I think that's a question that you would have to direct to the civil servants, because I have, in discussion with both my colleagues in the council and also with UEFA, we had always said that there were shortcomings in terms of the routine legislation that we deal with from a consumer protection point of view. And that's been made clear for some considerable time.
Okay. Thank you very much. Claire Baker.
Thank you, Convener. Apologies for my delay in arriving this morning. Can I ask last week we asked questions about if any lessons were learned from the Commonwealth Games. So for those who were involved in the enforcement procedures around the Commonwealth Games, is there any... I know you start to have discussions with traders who will be involved this time around. I do understand the discussions have been quite recent. Has there been any time taken to look back at what happened during the Commonwealth Games and whether there were any improvements or things that should change from the arrangements that were in place then?
During the process of carrying out enforcement at the Commonwealth Games and subsequently, we had a whole range of operational discussions about how we would do things slightly differently and how we would react to certain things. That experience, if you like, has then been used for other events. Last year, the European Championships, we used some of that experience, albeit that wasn't supported by primary legislation. And we've certainly learned from the nature of these major events on what we can expect in terms of attempts to breach or attempts to inadvertently breach. There was, in 2014, there were a number of businesses who I don't think were intending to breach legislation, but had misunderstood or not understood the restrictions in terms of the association rights and the trading and advertising. And once we'd had discussions with them, they were happily then complying with it. So those lessons have been learned. The big issue that we had, or one of the bigger issues we had, is the fact that the lots of businesses were well known for attempting to breach the rights of the host convener or the host event. So we now have better preparations for that should these major events come back to the city. We also shared that information with colleagues across the rest of Scotland and indeed the UK, because one of the things that happened during the Commonwealth Games was we had a number of officers who were assisting us with activity from different authorities, who were perhaps not as used to major events as people who work in Glasgow.
We did have, I'm struggling to find it right now, but we did have a letter from the Crown Office to say there were 4, I think, prosecutions for ticket touting. That was the only ones that went through the criminal process. Is that, do you have any?
None of those prosecutions were, none of those cases were reported by the enforcement officers. No. I understand that they may have come from Police Scotland because they had similar powers during the Games.
Yeah. I mean, you're talking about lessons learned, and you seem so far to be talking more about the involvement with businesses. When we had the Police Federation in front of us last week, they raised some issues about the working relationships and what were expected of the police in terms of what the expectation was. I don't think any of this is documented or reported. I suppose it was more a reflection on how the process had operated during the Commonwealth Games. I think they'd said that there were instances of conflict, and this was mainly over what enforcement officers expected police to do. Do you recognise that, or do you see that being an issue going forward?
No, I don't recognise it. There were, given the size of the operation and the occasional need for, which we do routinely in cooperation with the police, there were issues where there would be a difference of opinion about the nature of enforcement, and we would then discuss that with the police, and it was resolved. There were a couple of incidents where there had been a misunderstanding by the Games authorities in relation to the delivery by a couple of companies to Lesser Hampden. It was resolved in a couple of minutes, and it was a misunderstanding. It didn't impact, to my understanding, in any real way on the police's ability to carry out their functions, and it certainly didn't impinge on the reputation of the Games or the organisation. And we work with the police all day, every day. You know, I'm not aware of any big issues. There will occasionally be resourcing issues, which means that either we or they can't help each other, but that's something that's resolved by discussion. It's not a big issue.
Thank you.
So you can assure us that the police officers will get their lunch this time. There was some suggestion that they
got
their lunch last time, did they?
There was a delivery by two companies who were providing facilities to Lesser Hampden. They were in very well advertised vans and lorries. Those lorries were not part of the sponsorship arrangement. The organising committee felt that that was an intentional breach of the restrictions. It wasn't. It was a practical issue about if you have drinks and food to be delivered to a venue by particular companies, the reality is they will have branding on them. And nobody at the organising committee after discussion and us or the police had any real issue with that. There had been, which I think was why it had been raised, issues with other companies who were deliberately parking advertising vehicles within the commercial zone, and those had to be removed.
Okay. Thanks very much. Mike Grumbles.
Can I just first of all start with a question really to UEFA, because you were aware what my concerns were last week, and I've read your response to it. And if I just remind, I mean, we had the little discussion there about primary legislation and regulations. With primary legislation, our job is to interrogate the law of the land that we are making here that applies to everybody equally. And I'm a bit surprised by Section 2, subsection 4 about ticket outing, because we all want to see an end to this, and this is an appropriate way of dealing with the issue of ticket touting. But in your response from last week, you said UEFA only seeks an exemption from the ticket touting offence for the purpose of ensuring that the initial sale of tickets by UEFA is not caught by the offence and therefore prohibited. And then it says UEFA has absolutely no intention of touting tickets in the usual sense of that phrase. Now, I'm a bit surprised, because if we're banning ticket touting, we should be banning ticket touting, i.e. sale of a ticket above its price on the ticket. So, A, I don't understand why subsection 4 is there at all, giving UEFA exception from the law of the land. And also they will point about you have no intention of doing this, but that's not what the law says.
Fully understood. Thanks for the question. So to clarify our position, or to try and clarify it further, UEFA is the sole seller of any tickets for UEFA Euro 2020. It does so at a profit. It is our product that we sell, and because of that, the wording of the bill may regard a sale by UEFA as a sale for profit, which would then be caught by the touting, the definition of touting that's in the bill. Because it's not only sale above face value, it's sale above face value or sale with a view to making a profit. So the second part of that clause could trigger on UEFA's right to sell the ticket originally. And that's all that we're seeking to do here, is to ensure that that sale is not prohibited.
And that's the point of why we're doing this. Because what you're suggesting is that we take out section B, which says with a view to making a profit. Because ticket touting would be caught, would it not, in relation to the sale of a proposed sale of a championship ticket for an amount exceeding the ticket's face value.
I'm not going to suggest that just because I feel that I'm assuming that there is another secondary meaning behind that subsection in that clause that I'm not sure as to what it is catching. I'm sure, however, that the bill drafters and the bill team will be able to clarify that point. What I can assure you is that the traditional and the wording we use in our evidence about ticketing in the normal sense of the phrase, the reason we use that term is that touting is a legal definition in this bill. So therefore, and indeed, the touting as defined in the bill includes potentially the original point of sale of an original product by us for profit, and therefore that would actually prohibit us selling the tickets in the first place. So what we meant in our letter of evidence was that we have no intention of the traditional sense of touting, outside of the legislative definition, of reselling a ticket in an exploitative manner at a price above the face value. That is something that UEFA will never do.
Our job is to make sure the law is clear.
Of course.
And it strikes me, I mean, I understand exactly what you're saying, and your fear is that you would be caught literally selling the tickets to start with. So you're worried really about section 2, paragraph 2, subsection B, with a view to making a profit. Okay, so part of our job would be to perhaps, when we get the minister in, is to suggest that that is removed, so that you would not be caught by that, because there might just be an issue of us passing a law and what the law appears to be, because what this law, if it passed unamended, would appear to give UEFA special status about ticket, that it would allow it to ticket out if it wanted to do that. So I understand that. If I may move on to my other question about enforcement.
Yes, on you go.
Particularly to Glasgow. So thank you for that, Mr. Short. We heard last week from the Police Federation that enforcement officers with this bill will be given more powers than police officers. And in the bill in subsection 16, it says that Glasgow City Council may designate an individual as an enforcement officer only if the individual is an inspector of weights and measures under the 85 Act, or meets such other criteria as may be specified by Scottish ministers in regulations. And now again I come back to this issue of primary legislation or regulations. Our job as MSPs is to interrogate primary legislation because we can amend it if MSPs across the board think that can be improved by amending it. What we can't do is amend government regulations. So I'm always, as an individual, wary of giving regulatory power to ministers that MSPs cannot amend. So we've got now primary legislation. So my concern is if we're allowing Glasgow City Council to give powers that more than the police have to individuals, I don't have a worry about that if they are inspectors of weights and measures. That's fine. But it means this bill says it can appoint anybody according to Scottish Minister regulations, which we can't amend. So basically, what is the intention of Glasgow City Council in the appointment of enforcement officers? Are you going to appoint just inspectors of weights and measures from Glasgow City Council and bring in others from other local authorities? Or are you going to appoint people out with that?
Thank you for the question. I think the first thing I would make is that 27 under police powers make sure that constables have all the powers that enforcement officers have. There is no difference in terms of the enforcement powers. The difference for this particular issue is that the police have this, the issue here is that police have the same powers as the enforcement officers would have. So there isn't any...
Enforcement officers would have more powers than the police.
That is wrong.
So that evidence is wrong?
Yes.
Interesting.
Okay. I think a letter of clarification on that was submitted.
Okay. But even if they have the same powers, the point still stands.
Yeah. To your second point in relation to who we would intend to have as enforcement officers, because of the experience of the trading standards staff in Glasgow, and I should make it clear that that includes people who are not inspectors of weights and measures. There are 20 odd staff within the trading standards section in Glasgow, and roughly half of those people are inspectors of weights and measures. As the head of trading standards in Glasgow, I happen to be the chief inspector of weights and measures for the City of Glasgow, and it's a statutory appointment. But not everybody who carries out enforcement requires to be an inspector of weights and measures, which is why the second clause is there, to make sure that people who are suitably qualified and suitably experienced can carry out that enforcement role. And I would... not be expecting to appoint or second or gather anybody who was not suitably experienced.
Right. So they would be, in your view, they would be they would be employees in this field in Glasgow City
Yes.
Council or other council areas in Scotland,
Yes.
and nobody else. That would be,
Sorry.
and nobody else. That would be your intention, to just focus on that.
It would be people who are enforcement officers within the trading standards and consumer protection public regulation field.
And you would expect the Minister to put that in the regulations that come before Parliament?
I would have expected the Minister to give the authority to designate to effectively me.
Yeah, that's why I'm asking you
so
the
that I
question.
can then make an assessment as to whether or not those people are suitably qualified.
That's fine. Thank you. Thank you, Convener.
Okay, thank you very much. Ross Greer.
Convener, just on the point of the Police Federation's evidence that the enforcement officers would have more powers than a police officer, right? The point they were making is that the enforcement officers will have more power than a police officer would normally have. Now, police officers will gain additional powers under this legislation as well, in effect, particularly around whether or not searches can be conducted with or without a warrant, etc. But I'll come back to that in a second, because I'd like to just ask Mr. Short first around this. UEFA's written submission on this was really useful. You'll be aware that this was an area of substantial concern at our last evidence session. And just to clarify, you've confirmed that UEFA don't go to that level of detail when specifying the kind of enforcement powers that a host country would need to give to these officers. But you do have a rights protection programme. Could you detail a little bit how a host country would be able to judge for itself whether it meets the criteria of the rights protection programme? Because the question the committee has at the moment, or one of the questions we've got, is whether or not these specific enforcement powers are required. And from UEFA's written evidence, you've said you've not specified that they have to be required. So what we're trying to figure out now is why it was judged here domestically that they were necessary. So if you could detail how you expect a host country to judge itself against the rights protection programme, that would be useful.
Yeah, I'll try my best, absolutely. On the specific question about whether we guide or give any requirements around enforcement officers, the clarity on that point was that there was absolutely no intention to at any stage require people who were not fully qualified and authorised and experienced to undertake any enforcement powers. We don't require a host city to ever go outside of their normal processes of using police officers and qualified local authority enforcement officers or trading standards. We always desire that host cities continue to use the resources that they have. On whether a host city can judge itself on the rights protection programme, the process we undertake is that we distribute what we phrase as a legal matrix to all the host cities. Which we then discuss at various meetings and receive inputs from lots of different stakeholders involved with enforcement powers in that city. That document is standard across the board, across all 12 host cities, and details all of the areas of concern that our rights protection programme includes, including such things as ambush marketing, counterfeit goods, unauthorized advertising, ticket touting, and various other more granular versions of that. That document's completed and then discussed, and was discussed indeed in this instance, around a table with all the stakeholders in the room. Examples up on the screen, and we discuss as a group what tools are currently in place, who would undertake them, and the effectiveness of the current tools. So it's a very, in our opinion, a very collaborative approach, using a standardized document across the board, whereby the answers are then considered, reviewed and evaluated by everybody, and then recommendations made thereafter.
Thank you. And just to kind of drill down on the specific concern that has arisen around this, where the specific enforcement powers that have caused concern, so around the searching of property, the seizure and destruction of property, were those powers to be held only by police officers, i.e. where the proposals to give them to enforcement officers of the City Council amended out of the bill, but those powers would still exist. Police officers could still conduct any required operation there. Would that still meet UEFA's requirements?
It would meet UEFA's requirements, provided that the host city can then make themselves comfortable that they have the adequate resources to be able to do it. Who does the activity is not defined or mandated by UEFA. That it's able to be done practically and pragmatically is. So usually this extension or this sharing of responsibilities or defining of responsibilities is a resources question based around making sure that adequately trained and experienced people and an adequate number of them are available. So forgive me for the long answer. The short answer would be no. However, there is a resourcing question that lies underneath it.
That was useful, thank you. And just to come back to the City Council, and around exactly this same point, you'll be aware, you've seen the evidence submitted by the Police Federation here. Just to clarify in terms of the process that's brought us to this point, was it the City Council that advocated that these specific enforcement powers should be given under the primary legislation to trading standards officers? Or to the City Council to appoint?
The reality is that these powers are needed in order to carry out the effective control of trading and advertising in the controlled zones. I had an expectation that those powers would fall to the trading standards section and jointly with the police. I never made a recommendation that it should be the police or trading standards. It was my expectation, and that was based on experience of the Commonwealth Games, of a whole number of other areas of trade and consumer protection, where or brand protection, where it is normally the trading standards services that lead on the functions of and brand protection. But it wasn't me. I didn't insist on the extra powers, but they are necessary in terms of carrying out the control function.
Just on this specific question then of, do enforcement officers need to hold these powers, or can they use the services of the police where called upon? So one of the concerns that was raised was around their ability to search property, and particularly the question of what defines with or without the use of force to enter property. So the use of a locksmith would apparently not be defined as use of force, so the Police Federation were concerned about that. Is it really necessary for an enforcement officer to have the ability to, with the aid of a locksmith, enter a property to search it, when they could in fact simply call upon a police officer to do that for them? Those are the kind of operations that any member of the public would regard as being normally an area in which you would call on the services of the police. I mean, I'm trying to figure out how much of a problem would it actually cause you if in these specific circumstances of, particularly around searching property, entering property, to call upon the police if required to do that, because it's surely not going to be required that often.
I would agree that it is a resourcing question. I would also say that given the profile of the events, given that the police have huge other responsibilities in relation to protecting the public, to tackling or protecting the public from all sorts of other activity, including counter-terrorism, etc., that what I wouldn't want to do is have a position where a very short-term requirement, which these will be, given the nature of the competition, would then be delayed because we were taking police officers away from other activity. I don't know if it provides any reassurance, but during the entire period of the Commonwealth Games, we did not use the power to enter a domestic dwelling at all. We entered lots of business premises, and I have the powers under all sorts of other legislation to enter business premises and indeed to enter a domestic dwelling, provided they are used in conjunction with a business. So these are not powers that we are not familiar with. They are phrased in a different way and they are for a different purpose. But it's stuff that trading standard staff deal with on a fairly routine basis.
Thank you.
Yes, yes, of course.
Thank you very much. But on section 21 of the bill, that doesn't give you the power to enter households. Section 21 says if you do enter a household, you have to be accompanied by a constable. On section 20, you don't have the power to enter a house on your own as an enforcement officer. Section 21 says you must do it at reasonable times and accompanied by a constable.
But my point, sorry, I should have been more clear, was that if the police were doing this as the only authority that had those functions, then they would be taking 2 or more police officers away from functions to do that. If they do it with the support, if trading standards do that with the support and consent of a police constable, then we're only taking 1 constable away from duty.
The law says, this law that we're looking at, a constable.
Yes, that's what I'm saying. But if you're normally, for reasons of corroboration, if they were to go into a domestic dwelling, or, sorry, any premises, they would take 2 officers. So you'd be removing an additional officer from the process.
But the point, there's not an issue of corroboration because the enforcement officer would be there to corroborate. The bill actually says if you're only allowed to enter with a warrant issued by a sheriff, if accompanied by a police constable. So
it's a police officer.
So you see, but yes, but in your answer to Ross Greer, you seem to give the impression that you hadn't entered any premises under the previous event. Yeah. But the enforcement officers are not allowed to, even with this bill, will not be allowed to enter premises on their own.
No,
that's fine.
Sorry,
yeah, that's fine.
Acknowledging that.
Yeah.
Okay, thank you very much. Alexander Stewart.
You've touched on already, Mr Cockett, about the traders and the business community. And I think communications is going to be vitally important. And you've acknowledged what you've done in the past when it's come to engagement with some of those traders and that business community. So can I ask you what engagement you've had to date, what engagement you have planned to inform and to make sure that as many of the business community and the traders who will be involved in this whole process, the zones they are in, are going to be implemented in the, with reference to the bill, and the bill would have an impact on their trade and their business process?
At the end of August, there were 2 public engagement sessions where a number of people were invited to view what would have been draft and are draft maps of the zones that have some potential control over them or restriction on them. That type of process will be continued. Once the legislative process is complete, if it is, then what we would do is have further public meetings. We'd also engage with businesses that we know and will identify or have identified as being within these areas, to make sure that they understand the requirements and the restrictions that are placed on them. In addition to that, what we would do is contact business and trade organisations to make sure that they were also aware of that. And we would then use the normal public and press process to highlight the fact that there would be changes surrounding the Euro 2020 competition.
Can I ask how successful have they been? Did you get a reasonable turnout at these engagement sessions?
During the Commonwealth Games, once the bill had become an act and the regulations were in place, there was very good attendance at public sessions, both in each of the venues, because there were obviously more than one venue at that point, but also in the more general business community engagement sessions were well attended. And I would expect that to be the case once we can give much more detail about the absolute boundaries and identify particular businesses.
For those who are not able to attend that, there's still an online, there's another session that they can tap into, because not all would be able to maybe turn up to a physical event, but they would still require to have that information transmitted to them and given that.
We would certainly make sure that all the businesses that were directly affected would be informed and being given the opportunity to either engage at a public event or engage, and I use the term advisedly, privately, because they may have individual questions that they don't necessarily want to go through a public meeting.
Okay, thank you for that. If I can now move on to the SFA, can I ask a specific there? In the past, the SFA would normally operate their pop-up shop outside Hampden if there was an event of this nature or a game taking place with Scotland, etc. Is it your intention to do something similar during this if it's successful?
To answer the question, yeah, we would obviously work in tandem with UEFA in terms of what we were permitted to do relative to a potential Scotland match at Hampden Park. Clearly, we understand that obviously UEFA has exclusivity in terms of the Hampden Park campus and in terms of the commercial programme that's implemented there. So that's a matter that clearly at the appropriate time we would liaise directly with UEFA on. My understanding is that we probably would not be permitted to carry out such activity, as that programme would be run entirely by UEFA.
Thank you, Convener.
Very much. Emma Harper.
Thank you, Convener. Good morning, everybody. I'm interested in training of enforcement officers. In our briefing, it says that enforcement officers will be drawn from staff members in the Glasgow City Council, and so I'm interested in how is training to be planned and how is it carried out, and how many people then will be required to have additional education. I'm assuming that many of the trading standards enforcement officers will have already had experience from Commonwealth Games, for instance.
Thank you. Yes. All of the staff, with one exception, were involved in the Commonwealth Games. And all of them were involved in the European Championships last year. And all of them have been involved in similar large events. Some of us who are more mature were even at the previous UEFA events in the early 2000s. Some of us were even there in the 1990s and 1980s. But the training package we have, and part of that is because this bill has been drafted with the Commonwealth Games Act in mind, or in the as an advisory package, is that what we then have is a training package that takes the staff through not only the provisions of the bills or the Act, if it becomes one, and the regulations, but also the details of the planning areas and the commercial zones. It also reinforces the enforcement provisions and the enforcement policy that the Council has for every activity, which is our view and preference, is that businesses and individuals are encouraged into compliance before we take any formal enforcement action. And that experience was borne out during the Commonwealth Games when all of the activities that we dealt with the exception of the police reports in relation to, or potentially police reports in relation to touting, were dealt with by discussion and persuasion rather than more formal reports to the fiscal or similar activity. But the training package for this, I would envisage being probably a half day of training on the detail of the regulations and the bill, and a further half day on things like trademarks and association rights, to make sure that everybody within my team and anybody else was aware of exactly what the trademarks were and exactly what the association rights are.
Okay, thank you. And I'm assuming that the training would require liaising with the police so that everybody knows specific rules, so that good communication, collaboration and any misunderstandings can be potentially avoided if there's good liaising with the police.
We would, and we have already engaged with the police in relation to the events, and as a matter of course, what we would have done would be invite some police officers. I'm not volunteering to train the whole of Police Scotland, but we would invite some police officers to the training so that they were given the same level of briefing as the enforcement staff.
Okay, thank you.
Okay, thank you very much. Donald Cameron.
Can I return to the issue of primary legislation and ask the SFA about this? Did you have a role in the dialogue between UEFA and the Scottish Government about whether primary legislation was required?
Yes. To be clear, as Mr Short said earlier in his evidence submission, when we looked at the feasibility of bidding for UEFA Euro 2020, UEFA's tournament requirements and bid dossier templates were clear that there may be a need for primary legislation. That need was reflected within our bid submission to UEFA, and it was actually pulled up by UEFA's evaluation report in August of 2014. There has been a process of ongoing dialogue between the association and the various LOC board parties to the UEFA Euro 2020 Glasgow project over a number of years now about the potential need for the implementation of primary legislation. So, again, in taking the convener's point from the beginning of the meeting about the concern at the late arrival of this before the committee, there has been an ongoing process of consideration of the need for primary legislation for a period of time now, I have to say, and we have been party to that.
And your view, just to be clear, was that you may need it. Well, you didn't say you wanted it, yes or no. You just thought it was a potential requirement.
Our view, having assessed the legal requirements that were put forward by UEFA, is that it was very likely we would need it.
And did you, in terms of your contact with the Scottish Government, did you discuss it with them directly, with the Bill team?
Yeah, to be clear, the team delivering UEFA Euro 2020 Glasgow is a kind of a partnership between Scottish Football Association, Scottish ministers, Glasgow City Council, Hampden Park Limited, Visit Scotland. That same team has been together from the outset of the process, going back to 2013 when we actually considered the feasibility for the bid. So there has been ongoing dialogue with all officials across all of the sort of partner authorities about this need for a period of time.
So was, as far as you're aware, was the Scottish Government clear that this was a potential requirement?
The Scottish Government were aware that this may well be a potential requirement, and again wanted to fully investigate if there were opportunities in which to implement these measures in a different way. But yes, we were clear, and Scottish Government officials were clear too, that this ultimately may be required to be implemented.
Can I move to a different issue? This is really for Hampden Park. We've heard that the Hampden Park event zone is based very closely on the Commonwealth Games event zone. Has any evaluation been carried out in the aftermath of the Commonwealth Games about that zone and how it operated to take learning from that to inform this event?
In terms of the campus, and I can only speak for Hampden Park and the campus directly, I personally in Hampden Park Limited have been involved since 1999 across Champions League final 2002, 2007 UEFA Cup final, Olympic football matches 2012 and Glasgow 2014 Commonwealth Games. The size and scale of this event that is coming to Scotland, this is deemed to be the third biggest sporting event in the world. With that comes additional security implementations that have to be deployed on the campus. Therefore, Hampden's defined property, Hampden Park's defined property has to be expanded slightly with a security delineation slightly beyond the normal parameters of the stadium, which be termed as the outer security perimeter, particularly to the north of the stadium and to the east of the stadium. So in terms of the legislation that we are talking about here, this has to assist Hampden Park Limited and the Scottish FA to deliver the obligations of hosting such a tournament. And also will help UEFA to protect the commercial interests of the partners that are supporting the event. In terms of the particular event that's coming next year in June, the security perimeter, as I said, is slightly wider. We do understand that there are various official licences permitted within the vicinity of the stadium. Important to note, not on Hampden's campus, which has private property for any event at the stadium. In this particular instance, there'll be a security perimeter. By definition, any licensed traders who would normally fall within that particular security zone, I understand, will be offered an opportunity to potentially trade elsewhere. I'd also add that these particular matches are 4 additional matches to the busy schedule that Hampden Park has on a regular basis. And I understand that that opportunity to these traders was offered back in 2014 for the Commonwealth Games. I can't comment on how successful that was or if any of the licensed traders took up the opportunity. So there is an opportunity for traders to take up the opportunity presented.
Was there a formal evaluation of how the Commonwealth Games sort of had happened at Hampden that informs what's going to happen next year?
In terms of?
Just in terms of the zone, the event zone.
Yeah, the event zone, was there a formal, Glasgow City Council undertook a review, if you like, a post-event review of the operations. The campus delineation of the campus for this particular tournament very much follows the successful delivery of Euro 20 of the Commonwealth Games, whereby Hampden invited in the region of 480,000 people over 10 days, which worked successfully. From Hampden Park's point of view, we never had any negative fallout from that particular event, so it worked successfully. And this template, in terms of the stadium and the operation, the stadium follows a similar routine.
Thank you, Convener.
Thank you very much. Stuart McMillan.
No, it's the first question to Mr Coulthard in particular. Within the zones in Glasgow, are there any car garages? Particularly around Hampden, are there any car garages?
Sorry, do you mean domestic parking garages, or do you
car
mean
sales.
Service garages?
Car sales.
Car sales
Garages.
There will be one at least in the perimeter of Hampden. There isn't any in either the Merchant City or George Square venues. There used to be a second one in Hampden. My understanding is that that's currently ceased trading, but there is definitely one within the zone in Hampden.
Okay. I would just think, well, also one of the main sponsors is a vehicle manufacturer, and just thinking in terms of the if there are any car sales garages that potentially sells cars that are not from one of the main sponsors of the tournament, in terms of their advertising, their activities throughout the championship period in particular, how would that be dealt with? And also I've seen the list of exceptions, but how would that be dealt with? If they attempted to do some additional activities that were deemed to be kind of in contradiction to the law.
We have some experience of car dealers attempting to make an association between them and an event. We would make sure that the garage was well briefed about what it could and couldn't do. There wouldn't be any intention, as far as I am aware, to prevent normal trade taking place. What there would be a very careful scrutiny of whether or not they were attempting to make an unreasonable association between that business and UEFA or its sponsors. But that's something that we would do as part of the preparations for the regulations coming into force. We would carry out a survey of the businesses, not just garages, but all sorts of businesses in the areas that would be affected by the controls, to have an understanding of exactly what they currently do and how they operate their business, and then make sure that there hadn't been any unreasonable changes after the regulations came into force, and particularly during the restricted period around the competition itself.
A second question regarding also one of the sponsors is a delivery company.
Yep.
Now, what's to stop maybe a competitor company hiring people just to wear their particular outfits to go around the particular zones, and there, if they were stopped by either one of the enforcement officers or by the police, they could say, well, they've just delivered something and they're heading back to their vehicle. But what's to stop them from kind of not flooding, but certainly putting more people in just to do that guerrilla marketing within the zones in the championship period time?
The nature of our enforcement and our preparations would mean that we would have a reasonable intelligence about what activity was taking place within each of the areas. And if it was seen that a particular business was attempting to misuse their freedoms, if you like, in relation to business as usual, then that's something that we would take up with the business itself. The point made earlier on is that delivery vehicles, supply vehicles, all sorts of other things will inevitably be branded. Nobody is talking about banning them from the surrounding area, provided they are conducting their normal business. What we are not, that would be a failure on our part if what we then had was a series of vehicles for a competitor's, a sponsor's competitor parked up or circling the area or whatever. That's exactly the sort of discussions that we've had with UEFA about what we need to do in terms of controlling that type of activity.
Okay. And also the championship period is from the 1st of June to the 12th of July. But the Act itself will automatically be repealed on the 31st of December 2020. So in effect, the Act will still be in place, but obviously clearly you won't be doing all those activities after the period. So in terms of after the championship period, what type of activity would you then undertake in terms of if someone were to potentially still infringe upon what the bill is actually, so what the Act will actually say?
The normal process is that the controlled zones would only operate for those dates that you're talking about. If we found anything during that period and it required to be followed up and a report made to the fiscal, then we would continue to do those preparations after the competition had been completed. So we might still need powers after the completion of the actual competition, but we wouldn't intend to do anything other than the wind-up of any formal enforcement action after the period that the competition was completed.
So to Mr. Short, just regarding UEFA's corporate sponsors, can you provide some further information regarding the detail that the commercial sponsors actually and their protections are required certainly throughout the championship period of time? What is it they actually need? What is it they want in order to deliver what they deem to be part of their outcomes for sponsoring the event?
Certainly. Okay, I can speak to a reasonable extent on that. Some of the detail will be contained with our commercial sponsorship team, but I'll certainly try and assist. Within the security perimeters, within the zones where you require a ticket to attend a match, full exclusivity is provided to sponsors to do what we call activations, so to do promotions and to do advertising inside those spaces, and to licensees to sell product, exclusive area to sell product. That's within the tightest zone that we have, which is the security perimeter. The commercial perimeter or the event zone is an area whereby sponsors, where we are obligated to undertake the rights protection program, and therefore the sponsors benefit from the rights protection program. Within that space, they have a right to be the sole approved activation of any sort as a UEFA partner, whether that be advertising if you're a sponsor or sale if you're a licensee. So they have an expectation to be the only approved partner in that area, and that is effectively the event zone under this legislation. And then thereafter, simply the obligation is for us to undertake the rights protection program to increase the protection, the value of those rights within those areas, and those areas are then negotiated with the host city.
Is there a risk or a possibility that that the delivery on the ground will be different or slightly different in each of the host cities? So in effect, if a fan went to a number of games in different cities, they'd be very lucky to do so, of course, also because of the cost, but if they were to do that, is there then the possibility that they'll actually have a different experience, notwithstanding the city, of course, but have a different experience within the controlled zones in each of the different stadia?
So on that point, the controlled zones will obviously be slightly different. Everywhere you go, there'll be slightly different sizes and scales, just dependent upon the geography of the places, the stadia or the fan meeting or fan zones are located. So there'll be a slightly different experience there. Of course, in the commercial perimeter, in the event zones that we're talking about, it is all dependent upon the successful delivery of the rights protection program. So to answer your question, yes, of course it is possible. There is a risk that a fan or a spectator would experience ever so slightly a difference in delivery of that rights protection programme in each country, because it is dependent upon successful delivery by human beings, by local authorities and by police officers, who will all obviously have, for want of a better phrase, you know, different abilities and resources and good days and bad days and things like that. So of course we cannot 100% guarantee identity, but that is absolutely the contractual requirement and the objective.
And finally, well, obviously after each tournament, I would imagine there will be a great deal of work that will be undertaken to analyse the effectiveness of UEFA's requirements. And as a consequence of that, what lessons have UEFA learned from previous European Championships that you've requested or demanded to be implemented for the Euro 2020 Championships? Notwithstanding the fact, obviously, it's a different format this time, also in the different cities.
You anticipated the first part of my answer was that this is a unique event, and therefore, of course, experiences and lessons have been carried over from previous iterations. However, this is an event of no precedent, really. The lesson primarily here that we're carrying into this one is preparation, is clarity and training. So preparation, i.e. Having to deal with 12 different jurisdictions, requires more collaboration ahead of the event to manage expectations and to set those expectations at the same level given 12 different sets of laws. Clarity, to make sure that there is not uncertainty given the distances and varieties of locations and laws that are in place, to try and increase the clarity for local businesses, for our own sponsors and for fans. And then lastly, information. The lesson learned from the previous one is that you can never do enough to provide guidance and information to relevant stakeholders in advance of the event, and we're committed to doing that. We've done it before. This is not new, but we are committed to try and do it even better, use new techniques to do that, whether that be digital or online, and also resource it on the ground by getting people over here to help with the training and the guidance that's already been hinted at from Mr. Coulthard. And UEFA thoroughly supports that and will provide its resources and help to do that training and information distribution.
Thank you.
And Donald Cameron again.
Thank you, sir. Question for UEFA. And returning to the subject of ticket touting, you were asked questions by my colleague Mike Rumbles, and I heard what you said about not wanting to be caught by the for-profit element. Can I just be absolutely certain, I've reread your submission on this, is there any scenario under which UEFA would sell tickets above face value?
I'm not a ticketing expert, I'm not part of the ticketing department, but my answer to that is no. The face value is the face value. We are the original seller of a ticket, and we would always sell it at the face value. Even through the resale platform, the ticket is resold to another spectator at the same price. That is the terms and conditions of the resale platform.
Okay, thank you.
Thank you very much. You'll be aware that there was a discussion last week about the potential charity auctioning of tickets, which you've addressed in your written submission to us. It was obviously an issue that was raised by the Scottish Police Federation. To be perfectly honest, I wasn't absolutely clear in reading your submission as to what the position was of people who were auctioning tickets for charity, because although you said you weren't demanding that it was made illegal or anything, you still had certain rights. So could you clarify, you know, if someone is going to be auctioning UEFA tickets for charity, do they need to seek your permission? What's their position?
Certainly, I'll try and assist with that to the extent I can. The position is that a ticket sale for a UEFA event or for Euro 2020 is specific to the purchaser. The purchaser can buy a number of tickets and then allocate those tickets to guests and provide information regarding those people. But the key is that they are not resellable to an unknown third party under the ticketing terms and conditions that are signed up to when you purchase the ticket. So in other words, to put a summary to that, the ticket needs to be used by the original purchaser or a guest of the original purchaser. The reason that causes issues for auctions is obviously the ultimate holder of a ticket is unknown. And that is why any mechanism that involves a ticket moving to an unknown third party is a breach of the ticketing terms and conditions. For the purposes of charitable auctions here, we have absolutely no intention and would hope to ensure that this bill would never trigger any form of criminal offence on a charity seeking to do good work by auctioning off a ticket. However, the ticket that was used for it, to abide by the ticketing terms and conditions, would have to be a special ticket provided by UEFA that was able to be transferred to third parties. So that's how. Be special tickets. It would be, exactly. It would be, by pre-approving the promotion, right, they would get a ticket that is allowed to be used in the promotion, and we would speak to them ahead of the auction to do that. Right. And we're open to receiving requests like that. Yeah. Okay. Thank you very much. I've got Kenneth Gibson wants to come in.
Conveners, good morning, panel. It's just about the fan zones. I mean, I'm looking at the boundaries of them and I'm a bit mystified as to what the criteria have been for the designating the boundary of these fan zones. So, for example, if we look at the Hampden zone, I notice, for example, the junction of Cathcart Road and Kings Park Road is not really included in the fan zone, and as someone who has been to Hampden many times, from watching Scotland to St Mirren's glorious 1987 Cup final victory, that's a location where often fans buy, you know, the hats, the scarves, the badges, football programmes, etc. So that's not included in it. Kings Park Station is, but Queen Street Station isn't in the George Square one. So I'm just wondering what the thinking is behind the designation of the fan zones. I mean, I noticed, for example, that the fan zone in Glasgow also goes right behind the City Chambers, which is quite odd. I mean, I really wouldn't understand why that would be a location for fans. I can't imagine many fans, going behind the City Chambers. There really isn't anything there apart from anything else. So what's the thinking behind all
that? In terms of any area or commercial controlled area, you will always have to take a level of compromise. The easiest thing to do, and we wouldn't do it, but the easiest thing to do is to draw a big circle around a venue at some distance, which would then include everything area that people gather, etc. But in order to make sure that there is a reasonable balance between the restrictions that are in place for the commercial zone and free trade and free movement, etc., there has to be a compromise. That's why the drafted plan for the area around Hampden includes a slightly strange dogleg down to Kings Park Station. Because it would be unreasonable, I think, to include Kings Park Station simply by drawing an egg shape round the whole of the Hampden area that would include Kings Park. So there is always going to be a level of compromise and negotiation about those boundaries. One of the requirements, and it goes back to one of the points others have made before, that we need in terms of enforcement is an absolute clarity about where that boundary is. So some of the issues around the fan zones, the reason that they stop at particular junctions or may stop at particular junctions is to make absolutely sure that we can identify that that person is or is not inside the controlled zone. But all of these zones will have to be the subject of negotiation and discussion and clarification, because we wouldn't want to be in a position where we were overly restricting ordinary trade.
Yeah, I mean, I understand that. I mean, obviously, the youth will want to have its monopoly within that zone, but it's just that the zone boundary, and knowing the area really pretty well, actually, is that it just doesn't, to me, make much sense, particularly in Hampden, at the kind of south western end of Hampden, as I mentioned, Cathcart Road, etc., and Kings Park. That kind of junction, that's very, very busy. It's an avenue where the fans all pile through, and there'll be plenty of opportunities to buy ad hoc merchandise long before they get to the stadium. And if that's what you're trying to diminish, then I would have thought the zone should really be altered to take that kind of area into account, given the kind of obvious efforts you've made to ensure that the Kings Park Aitkenhead Road area is included. That's why I was trying to think about the logic, just as a fan who travels to the match often that way, you know. Yes, Mr Dallas, yes.
Maybe assist in terms of the immediate area around Hampden. There's maybe slight confusion in terms of there's the Hampden campus, which has got the outer security perimeter, and then there's the rights protection zone. The rights protection zone is the zone that you're alluding to, which is further out, which is distinctly different from a fan zone. There is no fan zone out at Hampden Park. We've got the Hampden campus, the rights protection zone, which is the wider areas that you refer to going towards the stations to protect the ticket touting and the branding, whereas in the city centre there are two delineated fan zones. It's just a slight difference in terminology.
Clean site zone perimeter, actually,
yes.
I think, is the specifics of it, yeah.
Yeah.
Okay, no, I was just wondering why it was drawn in those particular locations. That was why.
I think certainly, again, referring specifically to Hampden, the particularly Mount Florida railway station will be a main artery for fans travelling to the stadium and from transport hubs around the stadium. So therefore, the protected right zone is around the stadium to protect the commercial interests of UEFA's partners as the spectators approach the immediate vicinity of the stadium.
Okay, thanks very much. I won't pursue, but I'm just convinced. I'm not convinced that this is the right boundary from UEFA's point of view, because you know we're talking about a boundary literally yards from the stadium. I mean, it seems you come at that junction, you just turn right, and you're right at Lesser Hampden and Hampden itself. So I just don't understand why it's been drawn where it has. That's what I was trying to ascertain. It seems to be almost random. And I mean, again, Mr. Coulthard, why is it behind? Why have you drawn the boundary right behind the city chambers? I mean, there's no commercial activity there whatsoever, unless you want to buy a wedding dress.
I should say I didn't draw the boundaries, but the issue there is that if you look at the John Street, which runs at the back of the chambers, when there have been larger events in George Square, that has been an area where people have been offering for sale a variety of items. I should say that there are no licensed street traders in that area anyway, so it won't. The street trading part of it should not be affected necessarily all that much, because there is generally not a permission given for street trading within the George Square area anyway. However, we do know from experience that John Street has been used as a gathering point for people selling novelty type items at events.
Okay. Thanks very much, Convener.
Thank you. We just have one question from an additional question about enforcement from you, Ross Greer.
Yes, thanks, Convener. I realise time's short, so I'll just be brief. I'm just a bit concerned about Section 17(4) of the bill gives the enforcement officers the ability to essentially recruit anyone that they need to help them with enforcement. The wording is that they can recruit any other person as may be reasonably required for the purposes of taking action. I assume in most cases that would mean asking a police officer to help, but I was wondering, Mr. Coulthard, if you could just explain if there are situations in which it's not a police officer, who's the enforcement officer asking to help them, and to make sure that this isn't in effect a free-for-all, what are the criteria that would be put in place there?
The easiest example I could give you would be one where it was suggested that there was a breach of not only these provisions, but also the Trademarks Act. And what we might then do is ask somebody who was either from the brand to come and identify that this was indeed a counterfeit pair of Armani jeans or whatever the item was. And it's those sorts of, inverted commas, technical experts that we might bring in on a very rare occasion. Given the fluidity of enforcement, however, that's something that we would have to deal with on a practical, on a case-by-case basis. The other situation that we would have, and that was something that we did have to deal with at the Commonwealth Games, was where somebody had put a banner way above reasonable access ground level. What we then needed to do was bring in somebody who could use high access facilities, a cherry picker. in order to do that assistance. So it was a very specific, very carefully managed, controlled circumstances where it would be expert or technical help that would be required.
Right. Will individual enforcement officers have the power to make that decision, or if they are required to bring the kind of folk that you've just used as examples to kind of bring them in, would they be required to ask management, ask a supervisor before doing so? I'm just concerned about leaving this, what is, as written in the legislation, a very broad power in the hands of any individual enforcement officer.
Because of the ravages of resources and cost, I can guarantee you that any enforcement officer who is going to expect a cherry picker to be arriving anywhere in the Hampden or the surrounding areas would be getting my permission. Or sorry, would be asking for my permission. Whether they get it would be a matter that we'd have to deal with.
Yeah, I mean, the cherry pickers, I totally get that example. I suppose the concern, that the kind of stuff the Police Federation were concerned about is an enforcement officer needs a hand with something, so they get their big burly mate who lives around the corner to come and help them for 10 minutes, but they're protected under the legislation.
These provisions are required, but they are required in order to get technical or specialist help. They are not there to allow anybody to bring anybody else in for the sake of it. That's simply not going to happen.
Will you be defining that with your enforcement officers? Will you be setting out a decision-making framework for them?
Yes. Yes.
Right. Thank you.
The process that we have used in lots of these events is that there is minute-by-minute contact with all the enforcement officers who are then either ask for consent or permission to carry out particular activities or ask for advice. And they will be trained and briefed to the nth degree about the requirement to make sure that that happens on all these occasions, because what we also want to do is make sure that across the three different areas, the Hampden campus, the Merchant City and George Square, that the enforcement activity, the compliance requirements are identical, so that somebody who moved from one to the other shouldn't have a different experience in Glasgow. I accept the points made earlier that that might be different across Europe, but in Glasgow, their experience in terms of enforcement should be identical.
Thanks.
Okay, thanks very much. We have to finish up now, but I don't want to do so without raising the very important topic of young people busking, which was we devoted quite a lot of time to last week because, of course, we have many talented young people in Glasgow and it's a very popular activity. Now, the bill itself proposes to criminalise within the zones providing public entertainment for gain or reward, but in your submission, UEFA, you say that it's not an activity that is required to be prohibited under the Rights Protection Programme. So would you have any objections if it was dropped from the bill?
No, I would not have any objection if it was dropped from the bill at all. There would be, from a rights protection programme point of view, which is why it's worded that way, there may be other safety and security concerns about lots of people performing on the streets that other authorities or stakeholders might have an interest in making sure it doesn't get out of hand or unsafe in any way, given the traffic flows of people. But from a rights protection point of view and from UEFA's point of view, we very much hope that there's lots of busking to increase the atmosphere.
Okay, thank you very much. And we'll now suspend the session to have a changeover of witnesses. Thank you for coming to see us today. Thank you. We now move on to our second panel of witnesses on the UEFA European Championship Scotland Bill, and I would like to welcome Ben McPherson, Minister for Europe, Migration and International Development. And from the Scottish Government's Bill team, we have Lucy Carmichael, the Bill team leader, and Kirsten Simone Lefebvre, the Principal Legal Officer with the Scottish Government. I'd like to invite the Minister to make a brief opening statement. Thank you, Minister.
Good morning, Committee. I'm very pleased to be here to talk about the provisions of the UEFA European Championship Scotland Bill and how the Scottish Government proposes to use the powers contained in it, subject to parliamentary approval. We do so, of course, in the context of Glasgow's place among the world's top sporting destinations being confirmed when it was selected alongside the likes of Rome and London as one of the 12 Euro 2020 host cities. We are delighted to be involved in the 60th anniversary of the event, and we expect the economic benefits to be significant. And just as importantly, we expect that the buzz and memories it will create will be on par with other famous football matches that have taken place in Glasgow. Hosting these events often involves meeting certain requirements of the rights holder, and the bill will help ensure successful delivery of Euro 2020 by putting in place protections for commercial rights as appropriate and proportionate in relation to ticket touting, street trading and advertising. The provisions in the bill to ban ticket touting have been broadly supported since they were announced. Delivering this, along with the provisions on advertising and street trading, will reinforce Scotland's reputation as a gold standard host of major events. But it's important that these restrictions are proportionate, and so we are proposing that there are a number of exceptions to the trading and advertising offences. I know that charity collections and busking were raised during the evidence sessions last week and earlier this morning, and I'm pleased to confirm that we will propose that both of these activities are exceptions to the trading offence in the regulations. And my officials provided further information on proposed exceptions to the advertising offence earlier this week. This includes issues which I understand are important for advertising stakeholders, such as permitting advertising on buses and taxis that enter the event zones. I expect to share illustrative regulations with the committee very soon that will set out further details on how the Scottish Government expects to use its powers in the bill, which I hope will aid your consideration. I'm grateful for the points raised by the committee members last week and this morning in evidence sessions, and I trust that the Scottish Government's letter of Monday, October the 7th, clarifies the position and perhaps alleviates concerns on a number of matters. For example, the Scottish Government is proposing that all enforcement officers are local authority members of staff, and we would be happy to consider whether that could be included on the face of the bill. Developing a bill is, of course, a process, and I am very happy to listen to suggestions on areas where the bill might be improved through amendments. In conclusion, in light of the expedited timescale, I also want to say how grateful I am to the committee for undertaking consideration of the bill so swiftly. I also want to provide reassurance that the Scottish Government, along with Glasgow City Council, intends to continue to publicise the restrictions on advertising, street trading and ticket touting in the run-up to the event to raise awareness among businesses and the public. And I look forward to providing more information today on both the rationale for the bill and how it is expected to operate in practice. Thank you, Convener.
Thank you very much, Mr McPherson. Can I start by asking you, you heard the first session where we spoke to UEFA and Glasgow City Council and indeed the Scottish Football Association about when it was understood that primary legislation might be necessary in Scotland, because obviously primary legislation hasn't been brought forward in every country that's hosting these games. And UEFA said it was made clear in the bid back in 2014. The SFA said that they flagged it up back in 2014, and of course Glasgow City Council were very aware of these matters because they had previously hosted the Commonwealth Games. So I guess my question is why it's taken so long for this primary legislation to be introduced to Parliament with so little notice when it was known back in 2014.
Thank you, Convener. As was alluded to this morning by other witnesses, Before April 2018, the Scottish Government and its partners were working to establish whether it would be possible to meet UEFA's requirements without primary legislation, and so using and relying on existing legislation. And being conscious of the pressures on parliamentary time, there was an aspiration to explore all possible angles and avenues that could be used to utilise existing legislation. However, it became clear through dialogue and examination by all parties, of course, including in principle the Scottish Government, that in order to meet the requirements of UEFA's as the rights holder, but also and the city agreement, but also to make sure that the ticket touting offence was effective in practice and protected people to the extent we want it to, that it became clear in April, and this was indeed demonstrated in correspondence by letter on the 1st of April from UEFA to the SFA and other parties, that primary legislation was going to be the most effective and most robust way in order to protect rights and also to protect people from ticket touting. And at that point, once that crystallised position, it was clear the Scottish Government moved swiftly in order to bring forward this primary legislation.
Yes, you know, certainly moved swiftly, and of course I am aware that you weren't in this post in 2014, and you have actually quite recently come into this post. So these decisions were not your decisions, but it does seem to have been a little bit late in the day when the decision was taken. And I just wondered, I mean, in terms of the ticket touting offence in particular, it does seem that there is a gap in Scots law in terms of you know, modern entertainment, that we don't seem to be able to cover ticket touting, and it doesn't seem practical that we should have to have special pieces of legislation every time a major international event comes. Do you think it's something we need to improve in terms of the law?
Well, in terms of currently the legislation for ticket touting that would be applicable would be Section 55 of the Civic Government Scotland Act 1982. However, that wouldn't cover online aspects of ticket touting. But also, there's, of course, the balance between devolved and reserved powers. What will be, I think, useful for the benefit of the common good after providing this legislation is approved by Parliament and in due course, once the games or once the tournament at the UEFA Championships have passed, we of course will examine the success of this legislation. I think that would give a good basis for wider consideration around the issues of ticket touting and whether going forward there would be merit in considering a potential framework bill on these issues. But I think at the moment we need to get this legislation right and see it work in practice and consider the matters thereafter.
So the committee is certainly working very hard to do that within the timetable. I welcome the points that you have made about busking and charitable activity. I noticed that the submission that the Scottish Government has made, the letters from the Scottish Government has made about the types of regulations, the exceptions that you expect to be putting into force through regulations. Busking is not mentioned. Can you give us a categorical assurance that it will be mentioned specifically in the regulations? Because clearly the alternative is to amend the bill to take out section 6 paragraph 2 D, which prohibits providing public entertainment for gain or reward. So clearly if busking wasn't mentioned in the regulations, then the bill would need to be amended.
Because busking is trading, then it will be relevant to that part of the legislation. But yes, we will seek within regulations to permit.
Right. Okay. Thank you very much, Claire Baker.
Thank you, convener. It's interesting, Minister, that you say following this piece of legislation there will be a thorough look to see how effective it was, because it doesn't seem like that happened with the Commonwealth Games legislation to any great degree, there seems to now be, in advance of this legislation, quite a lot of work to try and understand how the Commonwealth Games legislation, how effective it was or otherwise. There didn't seem to be, there's lots of anecdotal evidence, but there wasn't a thorough look at how did this legislation operate and could we grow from it or continue with some kind of legislation to tackle particularly the issue of ticket touting. And I do understand there's reserve powers involved there, so there's some limitations on what we can do. We received a letter this week following the evidence we had a couple of weeks ago around the offences. So there were 4 ticket touting offences that went to that were reported to the Crown Office. And in the letter it says the Scottish Government will discuss these cases with the Crown Office to see if it can share any further information that might help to inform development of the bill and associated regulations. It won't be able to help development of the bill, I don't imagine, because we don't have the timescales to enable that. So how will you look at the evidence from the Crown Office? How will it impact in any way on the current process we're going through because of timescales being so short?
Well, of course, we welcome the submission of evidence by the Crown Procurator Fiscal Service, and also I would make reference to the letter from officials clarifying that position on the 4 instances where the ticket touting offence was used with regard to the 2014 legislation. We will, officials are now engaging in a process of further dialogue and correspondence with the Crown Procurator Fiscal Service to understand how those worked in practice in order to inform our further consideration of the bill as we enter the next stages of this legislative process, providing the Parliament, of course, approves the bill at stage 1.
You also sent information this week that shows the comparison between the Commonwealth Games legislation and this piece of legislation. Were there any lessons learned or impact assessment that's made any changes, or do you anticipate this piece of legislation operating in the same way as the Commonwealth?
2014 legislation is the gold standard, and of course the 2014 legislation was thoroughly examined by Parliament and also was subject to consultation beforehand. I would say that the legislation before us today at this juncture is enhanced from the 2014 gold standard, with particular reference to section 9, where we are, for example, putting in alternative arrangements where existing trading is banned during the championship, in order to put that obligation on the council that they must offer alternative trading arrangements for street traders, for example. So we have sought to enhance the 2014 bill where appropriate, but also seen the 2014 bill as the gold standard, because in practice, from the anecdotal feedback that was received and the performance of the legislation during the period, was a successful piece of legislation that worked well.
Okay, thank you. Thank you very much. Mike Rumbles.
Morning, Minister.
Morning.
Team. I've got two issues, but can I start firstly with ticket outing? And can I just first of all say I'm very pleased to hear that you've listened to the evidence so far on other issues and been willing to confirm that you're going to make specific changes in regulations. So that's great. But I'd like to focus on ticket touting. We all want to see ticket touting gone. And this is a useful means of doing this in the bill. But I have to say that subsection 4 of section 2, which just immediately stuck out at me when I read it, was that the touting offence does not apply in relation to acts done by UEFA. And when we asked UEFA, you may have heard it this morning, UEFA were clear that they don't engage in ticket touting, and their aim is to sell the tickets at face value. Whether there's a service charge as well, that's part of the bill, I understand that. But they are not involved in ticket touting. What's concerning them is section 2, subsection 2B, which says, with a view to making a profit. And they thought, well, hang on, if UEFA makes a profit, that's what it's about. Therefore, they wanted that in. That's the impression they've given us. And so when I put it to him that if that was removed with a view to making a profit, and we concentrated solely on the face value of the ticket, they seem to be happy with that. And what's the Minister's view about that?
Thank you for that, and for the engagement on these sections of the bill. I think my understanding of viewing UEFA's evidence this morning, and also their written submission, was that the necessity for the continued inclusion of 22B is in order to cover the fact that UEFA will make profit from ticket sales. And the reason for its inclusion from my perspective, along with 2.4, is for the point of the fact that 2 relates also to 2.3, which is about catching the offensive ticket touting before the transaction actually takes place. So to deter ticket touting and particularly online advertising of it, for example. The continued inclusion of 2.2b is also necessary for an instance where, for example, someone says that they will give a ticket to another, but the profit will be, for example, for the provision of a service or good, rather than monetary value above the level of the face value of the ticket. So we believe that it's important to continue to have the inclusion of 2A and B because of its relation to section 2.3, but also the fact that 2B and 2.4 are interrelated to allow UEFA to make profit from ticket sales.
6B says the amount payable for any other goods or services which are to be acquired as a condition of sale. So you've already got that covered. That's already covered. So what stands out, and I think would stand out to any ordinary person, is the look of this, which says we want to ban ticket touting, but we're not going to ban UEFA ticket touting. And UEFA says, well, we don't want to ticket tout, so why is it in the bill? I don't understand generally, I don't understand the argument, because if ticket touting is selling or proposing to sell a ticket for more than its face value, it is covered. What 2B does is not necessary. And if you don't have 2B, then they're not worried about it.
Is required in order to allow UEFA to make profit from both initial sales and any resale through their reselling arrangement.
But they don't do that. In answer to Donald Cameron's question, when he followed it up, he's been absolutely explicit. He asked them, will you be selling the tickets, reselling the tickets over and above face value? And they said no.
I appreciate that, and I'm taking that as read as the position. But what I'm saying is, in selling a ticket in the first place, UEFA will make a profit, so 2B is necessary to cover that position.
That's not ticket touting.
I know, but the fact that UEFA will sell tickets in the first instance requires them to be exempted from the offence.
I'm genuinely not following this, because ticket touting, as explained here, is about, and as is generally understood, as being the sale of a ticket above its face value. Of course UEFA are making a profit. That's what they're here to do. Of course they are. Everybody accepts that. And what I'm trying to understand is there's as far as I can see, an unnecessary element here in 4, which says you are allowing the ticket touting offence doesn't apply to UEFA. Well, I think people might think that is rather odd.
2 as a whole, then 2 as a whole, including 2B, includes making a profit. So we're saying
that's not necessary, because
that UEFA is not and should not be disallowed from making a profit, and that's why 2.4 and 2.2b are required.
The profit in ticket touting, isn't it, is the profit that is gained by the ticket tout over and above the amount of money you purchased a ticket for. That's ticket touting, isn't it?
Yes, but any reselling of a ticket, say for example through UEFA's, so UEFA, as is detailed in their evidence, intends to set up a provision in order for people to resell tickets at face value.
At face value.
So
they're not ticket touting.
But there would still be a profit position involved in that.
We do seem to be going round and round in circles. Nobody's arguing we shouldn't make a profit.
I think actually the position is clear, and we agree on the same point. It's if there's a position around you and the committee don't feel that the legislation is clear, then we'll certainly take away that and consider it with regard to stage 2. But I think we're both clear on the position that, one, the UEFA does not seek to ticket out, and that's absolutely clear.
That's great.
But
so
also there needs to be a consideration as to
it
the mechanisms.
Let's move on. Absolutely
for
right.
UEFA making profit.
Can I look at enforcement? An enforcement officer. I'm pleased that your opening statement you said that the regulations would be as they're going to be about the officers that are going to be made into those appointments. That's great. But I don't know if you've seen the supplementary evidence given to us by the Police Federation. And I've temporarily lost it. But basically, they're worried about one of the issues on section 17, subparagraph 4, where it says, an enforcement officer may be assisted by any other person, as may be reasonably required, for the purposes of taking action under this section. And I know in the letter from Lucy Carmichael, she says these provisions do not allow enforcement officers to call upon others to help with general enforcement activity on a routine basis. You know, we are examining the letter of the law here. And as I read it, the letter of the law doesn't say what you've just said in your letter. The letter of the law is clear. And I'm just thinking, in the exceptional case that something happens, an enforcement officer grabs somebody to help them, and whatever action then takes place, that other person is protected by this, because it says an enforcement officer may be assisted by any other person, which it goes on. So the evidence from Cam Steele and the Police Federation was that they would like to see that remain, but including it, in addition, if that's the case, then a police officer needs to be present, a police constable needs to be present. That's the supplementary evidence from the Police Federation. Any comment on that, Minister?
Yeah, thank you for that question. If I may just address the enforcement powers as a whole with an answer to that question, because I think there are some important points that need to be emphasised and clarified that have been borne out from the evidence taken thus far as necessary to clarify. It's important to emphasise that powers 17, 18 and 19 are contingent on an implicit permission from the proprietor for enforcement officers to be engaged. So any use of force or entry are covered within 20 and to 28, but 17, 18 and 19 are in the instance when the proprietor has given permission of entry to an enforcement officer. And as was emphasised by Neil Coulthart in the last evidence session that you had, committee, 17.4 is for instances when, for example, certain third parties are required in order to deal with a situation of breach. The cherry picker example was given in the last evidence session. So I would just ask committee to be clear that 17, 18 and 19 are in instances when permission has been allowed by the proprietor, and that changes the nature of the consideration.
That's not what it says in front of me on section 19. Section 19 says an enforcement officer may without warrant, enter any place, and may search any place, any vehicle, vessel, container, other thing like that place, and there's an exception for entering houses where the police has to be accompanied. But that's a very wide power.
So the use of reasonable force and entry to residential property in 20 and 21 quite rightly have greater requirements in terms of warrant and accompaniment by officers. But as I said, 17, 18 and 19 are implicit that the permission of the proprietor has been granted.
Sorry, could you point me where it says that in 19?
As I said, it's implicit.
But it doesn't say it, does it?
Well, it's to underwrite the powers of the enforcement officers to undertake their duties if given permission by the individuals
Well, forgive
involved.
me, Mr.
So we can take, if that implicit sense of permission is something that quite, and I appreciate that the committee has engaged on issues surrounding that within the evidence that's been taken so far. So we can certainly take that away in terms of further consideration towards stage 2. But I would just want to point out that it is an implicit point within 17, 18 and 19 that the proprietor has given permission.
My final question, I know time is short, but my final point is, that is the whole point, the intention, the good intentions that the government has in doing this. We all want to achieve the right aim here. Our job is to look at the letter of the law that we're putting in here, the letter, not the intention behind it, unless there are regulations coming out in some areas which there are. But our job is to look at this, Section 19 is quite clear. They have very huge powers, and the evidence that is given to us, the enforcement officers, will have huge powers, equivalent to a police officer. And there are, well, that's the evidence that's been given to us. The government has a particular view. Our job is to look at the bill before us, and the wording of the bill before us gives this protections to enforcement officers, and the police federation certainly are concerned about that, and I think rightly so. And all we're trying to do is make sure that we tighten this regulation up to avoid a problem that might occur. Hopefully nothing will go wrong and everything will be fine, but our job is to make sure that all the T's are crossed and the I's are dotted, and I think this is a problem. And I'm glad to hear that you're going to have a look at this, because I would hope that you bring amendments forward at stage 2 so we don't have to.
As I said, I think with the implicit position that permission would be granted by the proprietor for 17, 18 and 19, then this is the wording in 19.1 is just to clarify the position of enforcement officers once in a premises, having been given permission by the proprietor to enter.
Okay, thank you very much, Ross Greer.
Thank you, Convener. Part of the issue here around giving enforcement officers the ability to do this is, I get that a lot of it depends on the consent of the individual whose property might be searching, etc. The reality is, most people are not well versed in the intricacies of the law and their rights, and when someone turns up at their property in uniform, in often personal protective equipment that gives the appearance of them looking somewhat like a police officer, even if they're clearly not a police officer, most people are not going to be entirely sure what rights they have to refuse that person or not. But to stick with the point around 17.4 in particular, Minister, you said in your opening statement, it was very welcome, that you would consider adding to the face of the bill the point that all enforcement officers would be local authority staff, so primarily the trading standard staff. But 17.4, as we've just been talking about, gives these enforcement officers the ability to draw other people into their activities as required. Could you clarify if these other individuals who are being brought in are then given the same protections under this legislation for their activities that an enforcement officer would be? Because we've had undertakings from Glasgow City Council about the level of training that is going to be required of their enforcement officers, but nothing about any individual that they might need to help them. So I'm concerned about what the effect this legislation would give to the individuals the enforcement officers would seek to support them in their activities, when there's obviously no undertaking that those individuals are going to be trained, because a lot of this is going to be done on very short notice, and you wouldn't train the cherry picker operator in the intricacies of this bill and what an enforcement officer should do, because they're not an enforcement officer. But under my reading of 17.4, they potentially have the protections of this legislation extended to them and their activities as requested by the enforcement officer.
As mentioned, in terms of 16, our intention is that the enforcement officers will be local authority employees, and that primarily they will be from trading standards officers of Glasgow City Council. And we will, as I said in my opening statement, take away how to potentially amend 16 to make that clear. In terms of 17.4, the individuals who may assist and be reasonably required, and there's a reasonable test there for the purposes of taking action under that section, would not be enforcement officers, and so would not have the would not be designated enforcement officers under this legislation. And as was illustrated by Neil Holtart, this is in order to such individuals that were accompanying an enforcement officer in an instance would be those that the enforcement officer believed were reasonably required for the purposes of taking action. So that would be, and a number of examples were given in the previous session. So they are not enforcement officers, they are accompanying enforcement officers and would not have the same status under this legislation.
Right, I'm still concerned about the legislation as written, what effect that would give and what defence it would allow those individuals to make if it came to it. But to move it on slightly, under this legislation, the test for enforcement officers for activity short of that requires a warrant, etc. The enforcement officer is essentially asked to make a personal judgment about what would be an appropriate course of action. What would happen if an enforcement officer and a police officer took a contrary points of view on the appropriate course of action in an individual situation related to the powers that they would both have? So not related to powers of arrest, etc., that clearly lie with the police officer, but in relation to search, seizure, etc. If an enforcement officer and a police officer came to two contrary points of view in the one situation, who wins out there?
With regard to 20 or 21?
Primarily, yes.
So the understanding in terms of sections 20 and 21 are in a position where under a process of reasonable investigation, an enforcement officer believes that it would be necessary to use force to enter a premises or to, and then in terms of section 21 with regard to a home, which of course is quite rightly much more stringently protected in terms of the necessity and the requirements with regard to accompaniment of an officer and with regard to warrants. So the position is that enforcement officers would, in those instances where a use of force was required or entry into a residential house was required in their judgment after investigation, they would then be engaging with Police Scotland for the necessary assistance as articulated in the legislation. So I don't see a position where there would be a conflict of interest between what the Police Scotland would be intending to do in an enforcement. Perhaps an example would help me understand your point.
If we were to take out the searching beyond the use of force, so one concern that's been given is that the use of a locksmith to gain entry would not be considered use of force. If you're in the situation where an enforcement officer has decided that they need to gain entry to premises, that they require the assistance of a locksmith to gain entry to the premises, but a police officer considers that that is disproportionate and that entry to those premises is not required, who wins out?
I'm struggling to think of a situation where that would be the case because of the fact that an enforcement officer would only would reach out for the assistance of Police Scotland in such an instance where it was required under 20 to 28.
So there are situations where the enforcement officers don't need to require the assistance of a police officer.
So why would the police officer be involved?
A police officer could still be present in those circumstances,
right, okay.
Is the point. For example, if the individual the enforcement officer is in dispute with decided to summon a police officer.
Well, the enforcement officer would have the powers, as under this Act, to undertake what they deem to be necessary.
Even a police officer who was present, for example, because they were called by the individual who's locked premises, the enforcement officers decide they're going to use a locksmith to get into. If an individual is in dispute with an enforcement officer, if they summon a police officer because they believe the enforcement officer intends to take action that is disproportionate or unacceptable, are you saying that the enforcement officer can still undertake that action even if the police officer agrees that their action is disproportionate, unnecessary, unrequired, etc.?
No, I'm not saying that.
So what happens in that situation? The core point here is what happens if an enforcement officer and a police officer come to contrary point of view?
Well, again, I'm struggling to envisage a position where that would be the case. But in theory, and I think it would only be in theory, example, the police officer has more powers than an enforcement officer, and that is made clear within the legislation. Do you want to come in on this at all, Kirsty?
Yes. Under Section 19, the power to enter and search, as the Minister already explained, is only able to be carried out where permission of the person in charge of the property is given. Where the permission is not given and a locksmith would be required to gain entry, then Section 20 would apply, and the restrictions in Section 20 would apply that either a warrant and accompaniment by a constable is given, or a constable would make the call as to whether it was appropriate to gain entry by using reasonable force. So in the example you give, although the enforcement powers given to the enforcement officers are fairly wide for making decisions, in that particular example you give, it would actually be the constable who would decide if no warrant were given.
I'll finish then with just the wider point. UEFA confirmed this morning that they don't make requirements of any host country to the level of specificity of exactly what enforcement powers they would want enforcement officers to have. So that led us to the wider question of why it is required to give enforcement officers these particular powers around search, seizure, destruction, etc. So the remaining question I've got then, Minister, is why in the Scottish Government's view is it necessary to give these powers to enforcement officers and not simply leave them with the police? Is this a question of resources, as was indicated by the City Council?
Well, like I said, between 17, 18 and 19, there's an implicit requirement of permission. So the deployment of enforcement officers for undertaking the necessary investigations and enforcement of the requirements under the host city agreement and delivering this event successfully, it's a more effective use of resources, again with the implicit permission that's required with 17, 18 and 19 for enforcement officers to undertake that work. Enforcement officers also, as was articulated this morning, have the experience and will have the training in this to undertake it very effectively, and have done in previous tournaments. But what's also the previous events rather. But what's also clear is that in terms of use of force and entry to a residential property, then the requirements on officer, the need for officers to be present are very clear in the legislation in 20 and moving forward in terms of that section. So I believe there will be significant demands on Police Scotland during this event, and it makes better sense in terms of resources and utilisation of expertise for enforcement officers to be the ones undertaking this work, just as they did successfully in 2014.
Thanks. I'm conscious of time, Convener. If there's time at the end, I'd like to come back in.
I would just like to flag up the Police Federation's latest letter to the committee, where they basically say that the execution of the warrant should lie with the police, and that they are concerned with the question of primacy and the impression that the constable would be acting under the direction of an enforcement officer, which they obviously disagree with. They say the constable should only act in support of the warrant. Are you saying that they're wrong?
The intention of the legislation in terms of the enforcement officer's position within that is because the enforcement officer would have generally, in the majority of cases, been the individual who's undertaking the investigation and the examination of whether a breach has taken place. And for those reasons, it's logical that the enforcement officer would be the one engaging primarily in the investigation, but quite rightly there are the safeguards in 20 and 21 in particular that either warrants would have to be obtained as appropriate or police officers would have to accompany as appropriate.
Right. Mike?
There's a specific one. I can give an example, like we were struggling before about this. Ignoring houses because there are protections and ignoring force because there are protections. 19 says quite specifically, well, first of all, a police officer needs a warrant to enter premises at the moment in law. A police officer needs a warrant signed by a sheriff or someone else that they can enter a property. 19 says an enforcement officer may, without a warrant, enter any place if they believe an offence has been committed. It's different if a policeman says it's about to be committed or is being committed, they can enter, but not if it has been. So this gives extra powers to an enforcement officer. Well, the reason is, the example that was given was of a locksmith not using force to gain entry. So we'll have a situation where your policeman arrives, the enforcement officer arrives, the enforcement officer says, no, this gives me the power to enter this premises, which isn't a house, these premises without a warrant, I don't need a warrant, and I'm not using force. But the policeman says, I don't have that power. There's the example.
But I think it's important, as I said at the beginning, to emphasise that 19, along with 17 and 18, is implicit on the permission of the proprietor to enter.
It doesn't say that.
So the fact that it says without warrant is for clarity.
No,
in
where
that situation.
Where does it say that you can't, you can enter with, you keep saying it's implicit, but I can't see it anywhere in the bill.
Well, it's implicit.
It's not maybe what your intention is, but it's not what's before us.
It's implicit, but Kirsten, do you want to come in on that?
Section 19 is subject to sections 20 and 21.
Yes, that's about reasonable force. I've said that already. It's about reasonable force and about houses.
Yes.
Ignoring those, you can have a premise which is not a house.
Yes.
And you can have a locksmith entering that premises which is not using force. That's the example I'm giving.
Using a locksmith would be using reasonable force, because obviously you would only use a locksmith when no permission was given.
So may I come in again that obviously if you're not given permission, then use of force is required.
Where does it say you have to have permission?
But if you look at, you have to read the section as a whole, the sections as a whole.
That?
So, but it makes clear that in terms of, so if you look at 21, then 21 makes it clear that use of force
No,
is
that's
required.
about entering houses. That's about entering houses.
No,
I've said that.
20, section 1.
20. That's about using force.
Yeah, that's what. So
I've said, well, not using force and not using houses.
So if you let me come in, Mr. Rumbles. So it's clear
Okay,
that
it's not clear.
that force that it's implicit between 17, 18, 19 that permission is granted in those instances, because when permission isn't granted, would only create the occurrence where use of force was needed, and that's why when use of force is required, i.e. when there's not permission, then section 20 is applicable. So you have to read the sections together in order to get the full meaning.
I don't think Mr Rumbles is convinced, but we
No,
need
I'm
to
not,
bring other
certainly
members
not
in,
convinced,
so
I'm
I'm going to
afraid.
move on to Emma Harper.
Good morning. Thank you for coming today, Minister. It's just a really quick question. There's 3 event zones in the proposed bill: Hampden Park, George Square and Merchant City Zone. And there's proposals to ban advertising and outdoor trading within the zones. And the tournament runs for 6 weeks, from 1st of June to the 12th of July. So are the zones applicable for that time frame, or only when games are being played on game day? Because I'm imagining that during the 6 weeks, when there's no games being played, businesses and street vendors or whatever might just think we can just do business as usual.
So I would refer to the definitions of the championship period, and so the intention is for the zones to be in place for the between the 1st and the 30th of June in terms of Hampden Park, because that will be the requirement in terms of the games that are undertaken there. And the other zones, the George Square zone is from the 10th of June to the 12th of July, and that is because of the necessity for that zone to be part of the wider public's enjoyment of the tournament, both visiting fans and people who want to engage in watching the spectacle in a public space from Scotland as well. In terms of the operation of the Merchant City Zone, consideration of the dates of operation of that are still under consideration, because we want to make sure that it's done in the most proportionate way to facilitate that area for a fan zone, but also for the wider public. I mean, I think it's particularly with regard to the Hampden zone, the Merchant City zone, and the George Square zone, that the opportunity for economic opportunity for businesses in that area is going to be exceptionally high, and welcome extra custom. And in terms of the zone around Hampden, as you heard earlier, that's about how do we facilitate both the preparation of the stadium for the games that are taking place, but also making sure that there's the requirements that UEFA have set are undertaken through the process of the matches there.
And I'm assuming because of the different dates with the event, the zones in the three different areas, the businesses will have to be informed and kept up to date with what is required of them as far as game days and all of the business opportunities.
Absolutely, and we've already been engaging in that, both Scottish Government and other partners. So we've held 2 drop-in sessions in Glasgow, inviting street traders, businesses, media owners and equality groups to attend. The Federation of Small Businesses, Glasgow Chamber of Commerce, the Scottish Retail Consortium and Greater Glasgow Hoteliers Association were all also invited. Telephone calls have taken place with street traders and other businesses who could not attend in person, and we have been clear that these proposals are in draft and subject to parliamentary approval, so are looking to take feedback on the proposals from businesses, because we see this, and I think we should all see this, as a hugely beneficial event that's coming to Glasgow that will have a hugely positive economic impact for the country as a whole, but particularly for businesses that are located in these zones and in Glasgow as a whole.
Okay, thank you. Thanks.
Thank you very much, Donald Cameron.
I'd have to return to this, but the discussion this morning, as it's gone on, has revealed that this legislation is throwing up difficult and important questions, whether it's about ticket touting or about enforcement powers. And I hear what you say about there being an ongoing dialogue for the need for primary legislation, and I accept that you yourself have only been in your role recently. And of course, everyone wants this event to happen and to be a success. But the legislation that underpinned the Commonwealth Games was passed 6 years before that event happened. The UK Parliament is considering legislation now for the Commonwealth Games in 2022. Do you think it acceptable that 8 months before this event is due to take place, we are having to rush through legislation, especially when it seems that it was always likely, or at least there was a high possibility, that primary legislation was needed?
I share the position that ideally we would have had more time to consider this legislation, and I think that we would have been such earlier consideration would have been welcome by all parties. However, it was done with the best intentions of examining the current legislation that we have and seeking to maximise good use of parliamentary time. I think it's also important to emphasise that the fact that we have based this legislation before us today on the gold standard of what was passed in 2014 is a very strong position in which to examine legislation that was both effective and thoroughly scrutinised at the time. And actually, we're enhancing that legislation together through this process in order to have the strongest and most effective legislation in place for the delivery of this important and highly beneficial event for Scotland.
Can I get a commitment from you that going forward, obviously in the future, we all want Scotland to host big sporting events, but that it is not really a very acceptable way forward to be dealing with legislation ad hoc and at short notice, and that the government gives consideration, whether that's closing these loopholes in touting law that the convener spoke about earlier, but generally in how we approach and legislate for major sporting events. Will you give a commitment today that you will consider that in the future?
We will certainly evaluate this bill in due course and before any consideration of whether a future events framework bill might be appropriate. We would expect to undertake carefully consider the benefits of such a framework bill in future. But I think if we together deliver successful legislation here, just like what happened in 2014 for the Commonwealth Games, then that would provide a strong basis of analysis for consideration around a potential frameworks bill for major events in the future. Thank you.
Thank you very much. Stuart McMillan.
Thank you. Just also the championship period is from the 1st of June to the 12th of July, but the bill, so the Act, when it's passed, will automatically come off the statute book on the 31st of December 2020. So from the 12th of July to the end of December, that's a fairly long period of time for potential some unintended consequences. Has there been any consideration given to reducing that period of time?
Well, of course, the offences are connected to the championship period rather than the termination of the legislation. However, the cessation date of the 31st of December of this of 2020 was decided upon just for because of the nature of the annual year calendar end. However, certainly we can consider whether it would be if it's a pressing point for the committee, certainly open-minded to consideration of cessation at an earlier date if that's a strong position the committee takes.
Thank you. And the final question, just on the issue of the following on Donald Cameron's question. When we heard in the evidence session last week, the issue was raised just regarding the Scotland's current legislation regarding ticket touting, obviously being quite a bit of a challenge in terms of big events. Notwithstanding, say, Mr Cameron's question regarding some type of framework legislation, but after this event is over, and I think as we all expect and anticipate a hugely successful event for Scotland to promote the country, could even a short-term, kind of an immediate-term piece of work be undertaken in terms of just updating the ticket touting legislation to bring that into up to date, so that potentially could be removed from any type of ambiguity and any concerns for future major events that Scotland wants to hold?
Of course, one of the challenges around that is because of the nature of reserved and devolved powers and considerations between the two with regard to this matter. As I've committed to already today, there is an enthusiasm for undertaking consideration of the effectiveness of this legislation with regard to potentially a major events framework bill, and I think it would. I wouldn't want to presuppose that consideration. I think we deliver this legislation together. We make this event a success. We reflect on it. We reflect on previous events like the Commonwealth Games, and then we consider together whether a framework bill would be appropriate and effective for more expediency going forward.
Okay, thank you.
Okay, thank you very much. Alexander Stewart.
Thank you. We all want the event to be a success, Minister. You alluded to that. We want the fans to enjoy it. We want the public, the traders, everyone to be part and parcel of that process. And all, it will showcase us as a country and showcase the locations and all the rest of it. But there is knock-on effects for individuals and organisations that are within some of these zones. And the Advertising Association came up with some specific areas that they were concerned about when they were talking about some, for example, vehicles going into the zones that may have advertising material on them. Or it may well be the case that there's printed media going into the zones during the timescales of things taking place. So can I ask about what you are considering with the reference to exceptions within that whole process to ensure that these organisations and individuals will not be penalised in that process, and that they'll be able to trade and continue to do their normal business practice in the normal way?
Important question. I refer members to Annex A from the letter of the 7th of October from the Scottish Government. The first 2 bullet points, for example, state that distributing or providing current newspapers will be exempt in the regulations. Advertisements on or in moving vehicles, for example, buses, vans and trucks, but would not apply to vehicles whose use is primarily to display adverts. So we are seeking to be as practicable as possible in order to make sure that exemptions are reasonable. And also we are considering what might be required in regulations to disapply the offence for any existing commercial arrangements that have been entered into before the advertising offence is created. But it's all about how do we balance in terms of reasonableness for suitable exemptions, but also make sure that, quite understandably, the global partners that UEFA are engaged in are protected, given the significant resource that they contribute to this event in order to make it happen.
I think it's right that they are protected in this process because they have a bigger say in the situation. So I asked earlier on in the other panel about communication, how that was going to be communicated, how you're going to make sure that there was engagement with organisations and individuals to make sure that they knew what the parameters are and that they fall into those parameters and they don't, by mistake or by just situation, find themselves at the wrong side of it.
Absolutely, and as I said earlier, we've already had 2 drop-in sessions and held follow-up calls with businesses who would want to engage but weren't able to attend on the day, and we've indicated that we the level of impact we'd expect the legislation to have on their businesses. We're also trying to be proactive in this and again practicable by encouraging UEFA and other partners to correspond with businesses so that when consideration around advertising space in the event zones is being contracted, that there is a sense of reasonableness and proactivity towards satisfying both the needs of the global partners for UEFA and also the ambition for local organisations and businesses to sell their advertising space. So we are trying to do that. What's also true is that the bill says that Glasgow must publish guidance on street trading and advertising restrictions. So there's a clear requirement within the legislation for publication of guidance, and that's really important.
As you say, the guidance is vitally important that people know what the parameters that they've got to work within. Thank you, Convener.
Thank you. Ross Greer.
Thank you, Convener. I'd just like to look at section 19 in particular, the power to enter and search for enforcement officers, and particularly the ability to search. The phrase at the end of it is other thing at that place. So to search the contents of a place that is being searched, and specifically look at electronic devices. I mean, what are the limitations on enforcement officers in their ability, if they are able to search a premises and there is, for example, a laptop or a tablet, whatever there, maybe doesn't have a password or a particularly strong password on it. What are the restrictions on their ability to search an electronic device?
My understanding is that consideration of the ability to search electronic devices is covered in other legislation, and that this refers to the premises, again, remembering that Section 19 is implicit on permission, and I think it's important to keep emphasising that, that the powers that are contained are to do with physical premises and are not...
But it says any other thing at that place. So the physical premises is that place. And a thing that is at that place, that's objects contained within it. A laptop could be at a place, at a property that is being searched. Would that not fall under the definition?
But as I said, it's
19.1?
subject to permission, so only if the proprietor of both the premises and the laptop decided to grant the enforcement officer entry into the laptop. But as I said, there are protections on I would need to double check this, and certainly happy to follow up in writing on this. But my understanding from memory is that access to electronic devices is also covered in other legislation. But we can follow up on that. Do you want to come in, Kirsten?
Yes, it's to do with searching a place rather than a thing. The
But it says a thing.
brackets-
Sorry to interrupt. It does say
Sorry.
a thing at that place.
Yes, indeed it does. The opening words say that they may enter any place and search any place and any vehicle, vessel, container or other thing at that place. It means a physical search of something, which could be a tent or, you know, some kind of temporary structure. It's not really meant about searching within electronic devices. It's about searching a place, and the bracketed words are things in that place that can be searched as a place.
Right. I mean, that's absolutely not my reading of 19.1. So I think that the clarity is both required on the wording of the provision in 19.1, but also, Minister, if you could write to us with what you'd mentioned about the requirements that are contained in other legislation about searching electronic devices. That in and of itself would be useful, but clearly we need clarity about whether what 19.1 actually applies to, because thing at that place is, to me, an incredibly broad term. It would cover anything contained in the place that is being searched. It wouldn't just contain, as has been mentioned, temporary structures, temporary property. It just says thing, and thing has a pretty broad definition.
Certainly, as I said at the beginning, happy to consider what may provide clarity as appropriate. I guess I would just also want to be clear that, of course, again, that 19 is implicit on permission.
Yeah, I suppose, I mean, we've been over that a number of times this morning. There's certainly concern from members of the committee that implicit is not sufficient and that something on the face of this legislation is probably required. But yeah, if we could get clarity around 19.1 in particular and what that means, that would be very helpful.
Thank you.
Thanks.
Thank you very much. We're just about to finish up now, unless anyone else wants to come in. Could I just ask, I believe it was Lucy last week who said that you expected to have the illustrative regulations with the committee before our stage 1 report. Can you just confirm that that is the case?
Yes, I think that's in my letter as well, that we will have them to you by the 25th of October at the latest, but we're aiming to do it sooner than that.
That would be most welcome. Could I perhaps ask the Minister to reflect on the lines of questioning, particularly by Mr Rumbles and Mr Greer, with regards to the enforcement powers, and given the tight timescales, it might be helpful if you could perhaps provide more clarification on their lines of questioning in writing. And I'm particularly concerned about the latest letter from the Scottish Police Federation and their points about their concerns about the primacy of the police officer being somehow undermined in terms of the execution of the warrant. I wonder if you could, in writing to the committee, respond in detail to that point as well.
Certainly happy to, although I would just emphasise what I said earlier, that within the legislation we believe it is clear that the police officer would have primacy, and also the point I've made repeatedly today around the with regard to 17, 18 and 19, that there's an implicit permission from the proprietor with regard to them. But we'll certainly reflect both on the evidence received in writing and the committee's questions today and last week, whether there further clarification is required within the drafting. But I think if on reflection on those sections 17, 18 and 19, if you read them with the implicit sense of permission, I think a lot of the concerns that have been raised would be alleviated.
Okay, thank you very much. And we shall now close the session and move into private session.